Welcome to the Deep Dive. Today we're tackling a really significant topic in mental health care, community treatment orders, CTOs, basically.
That's right. These are, well, legal orders that mean individuals living outside hospitals have to get mandated mental health treatment right there in the community.
And the original idea, wasn't it, back when they started in Victoria, Australia in '86, was to move away from locking people up long term.
Exactly. Deinstitutionalization.
Mhm.
And providing care in what's called the least restrictive environment possible. That was the goal.
So for this deep dive, we've got materials from Justice Action, the NSW Mental Health Review Tribunal.
And some legal case analyses, too, all centered on CTOs.
Our mission, really, is to get a handle on what they are, how they work, why they seem to be used more often.
And explore the main arguments, the debates happening around them. Get into the nitty-gritty.
Okay, let's start with how one of these orders actually gets going, the legal side.
Sure. So in New South Wales, someone needs to apply to a tribunal.
And who can do that?
Well, it could be an authorized medical officer, usually a senior doctor in a mental health service,
Okay.
or another medical practitioner, the director of community treatment, or sometimes even the person's primary carer.
Right.
If the tribunal says yes, then a psychiatric case manager, the person coordinating their community care, puts together a treatment plan.
And that plan goes where?
It goes back to the tribunal or sometimes a magistrate. They make the final call on the treatment and the management conditions under the order.
Okay, so that's the process. What about how long these things last?
Yeah.
And are they used a lot?
Good question. The 2022 report from the NSW Mental Health Review Tribunal says they can be imposed for up to 12 months.
A whole year.
Yeah. But it also notes most are actually for 6 months or less, which, some might say suggests they're becoming maybe a bit of a default option rather than a last resort. It makes you wonder about other community supports.
And the numbers, are they increasing?
Well, in the year up to June 30, 2021, there were 679 new applications in NSW. That was an increase in hearings from the previous period.
Right.
The total number of applications hit 6,556 that year. That involved nearly 5,000 people, 4,985 individuals.
Those are, pretty big numbers.
Yeah.
So when they're deciding whether to impose one, what reasons do they usually give? What's the justification?
There are several common criteria cited. Often it involves the person having a severe and chronic mental illness, think schizophrenia, bipolar depression,
Okay.
where it's believed the illness impairs their ability to think rationally or maybe poses a danger to themselves or others.
Makes sense. What else?
Also, maybe a history where medication didn't work well or they refuse to continue treatment after weighing the pros and cons.
Uh-huh.
Sometimes negative past experiences in hospital mean that's not seen as suitable anymore.
I see.
And importantly, they state the person should fully grasp the CTO process and its conditions.
But it's not just about taking medication, is it? It involves more.
Definitely. A CTO often means regular monitoring, restrictions on activities and interventions if the person doesn't stick to the order's terms.
So we've got the official criteria, but the sources also hint that maybe the attitudes of the tribunals and doctors play a part too, how often they think the criteria are met.
That's a really crucial point. The 2022 NSW data showed a big jump in people under CTOs, 3,734, up from 3,146 the year before.
Wow.
But interestingly, the rate at which these orders were revoked, canceled, stayed pretty low.
So more people on them, but not many coming off them.
Exactly. And if you remember that Justice Action study finding many people didn't think the meds helped, well, does that low revocation rate maybe suggest a power imbalance, or perhaps it's hard for people to effectively appeal?
It certainly raises questions about whether every single decision is being made super carefully, considering the individual.
It does. And we saw an earlier jump, too, between 2012 and 2013. CTOs made in NSW went up by 10.3%. That was 5,180 hearings in total.
On mostly men.
Yeah, 253 males compared to 1,927 females in that period.
Which, naturally, brings us to the criticisms. And our sources suggest there's some pretty strong arguments against using CTOs.
Oh, absolutely. A major concern is that they're seen as, stepping on someone's basic rights, autonomy, freedom, making their own choices.
Even if they're meant as an alternative to hospital.
Right, because being forced into treatment, even in the community, with all the monitoring, that can seriously impact someone's life.
And do we know for sure they actually work better?
That's another key point. The sources say there's no sort of slam dunk conclusive evidence showing massive benefits or effectiveness across the board. Plus, there's the worry that just having these orders around might inadvertently increase the stigma people with mental illness already face.
Beyond the general criticisms, we also have perspectives from people who've actually been on these orders.
Yes, that Justice Action study you mentioned. They surveyed people with lived experience. And get this, 81% said they didn't think their prescribed medication was actually beneficial.
81%. That's huge.
It really is. And interestingly, some who did take the medication said they did it mainly to sort of stay on good terms with their treatment team.
Hoping for better care or to get out of the system sooner.
Exactly. It really highlights that for many people directly involved, the preference is not to take the prescribed meds.
Which underlines how little research we seem to have in Australia, specifically on what people actually want regarding medication.
Precisely. We don't have much local data. But there's research from overseas, like a Swedish study back in '96. They talked to people after forced medication.
And what did they find?
Many talked about being scared of side effects, worried about addiction, and just feeling controlled, resentful. Some were outright angry about the whole thing.
This ties into something else, advance directives, where people state their wishes for future treatment before they might lose capacity. How do they fit in?
It's a fascinating area. Legally speaking, especially in NSW, the Guardianship Act kind of implies a right to refuse treatment in advance. Yeah, it's not spelled out directly in statute for mental health treatment. You can put it in an appointment of enduring guardian document or a separate one.
But is it binding?
Here's the catch. If a guardian is appointed, their decisions override the advance directive if there's a conflict. However, even if not strictly binding under statute, they're generally seen as strongly persuasive, especially if they're clear, consistent, and recent. Common law principles might even make them legally binding if those conditions were met when they were made.
We have a case study that really shows this tension, don't we? Michael Riley.
Yes. In 2013, Michael Riley actually prepared an advance directive specifically trying to avoid a CTO.
What did it say?
It clearly stated that before he was scheduled under the Mental Health Act, one of his chosen delegates should be contacted. The idea was to work with them on a community support plan instead of just imposing a CTO.
Makes sense. Did it work?
No. He presented it to the Mental Health Review Tribunal, but they didn't accept it as sufficient grounds to stop the order. His CTO was renewed.
But why? Was he considered a serious risk?
That's the question. Section 14 of the Act says coercive treatment should only be necessary for protection from serious harm to self or others. Michael apparently had no criminal history, no record of violence. So the tribunal's decision to override his clear wishes seems, well, questionable in that context.
And these aren't just Australian issues, are they? We heard about Paul Chapman in the UK.
Right. Paul Chapman got a CTO in the UK in 2009. He felt it really damaged his family relationships.
How so?
He said it made his family feel like they were sort of responsible for him, had authority over him, instead of just being caring and compassionate.
Like it changed the dynamic.
Exactly. And he felt hugely stigmatized, too. He described it like wearing a tag, always under the threat of being sent straight back to hospital if he didn't comply.
And he couldn't get off it?
He asked formally, but his request was denied.
Then there's the Nathan Chetty case here in Australia, which sounds quite alarming.
Yes, Nathan Chetty was under a CTO from 2015. This involved involuntary hospital stays, monthly antipsychotic injections, really close surveillance.
Okay.
But in 2022, things got really concerning. He was arrested, detained for 6 days, and during that time, he was repeatedly injected without consent.
Without consent. What was the justification?
Apparently just vague references to safety. It wasn't clearly documented. This actually led to a revised treatment plan from the tribunal, which then put him in breach of his own CTO conditions. It's quite tangled.
That sounds like a real mess and potentially dangerous.
It does. His CTO was eventually stopped in April 2023, but his experience really highlights the risks when there aren't clear rules and oversight for how CTOs are actually implemented and enforced day to day.
We also heard about Kerry O'Malley's experience with forced medication.
Yes. Kerry O'Malley describes some really severe negative impacts from a forced medication order, both mental and physical.
Like rep.
Increased anxiety, lack of motivation, difficulty concentrating, weight gain, even hair loss, and just feeling degraded by the loss of autonomy.
It sounds like there are also concerns about the doctors managing these orders, their workload.
Yeah, the chief psychiatrist in Western Australia actually raised this. The worry is if psychiatrists are juggling too many CTOs.
You don't have enough time for each person.
Exactly. Not enough time to properly understand individual needs, which could mean the service isn't as effective as it could be.
We should also quickly mention Forensic community treatment orders, FCTOs, they're different, right? And unique to NSW.
That's correct. FCTOs allow forced medication for people with psychosocial challenges while they're in prison.
In prison.
Yes, which raises a whole host of ethical questions. Are they getting equivalent treatment to people in the community? What about their autonomy, bodily integrity inside a prison? Can proper care even be given in that restrictive setting?
But they're still used.
Despite those questions, yes, FCTOs are currently used in NSW. It's distinct from the standard community CTOs we've mostly been talking about.
Got it. Now, there's also this tool mentioned in NSW, the MHOAT, Mental Health Outcome Assessment Tool.
Right, the MHOAT. It's basically a statewide record to track how clinical interactions are going. It helps clinicians with things like triage, assessment, history taking, care planning.
Aiming for more efficiency?
Pretty much.
Right.
But, and this is important, under Section 14 of the Mental Health Act, it's not currently the main way mental illness is assessed for imposing orders.
But it could be used differently in future.
There's potential, perhaps, for it to eventually play a role in maybe setting some limits on the power of CTOs regarding forced medication, but it's not there yet.
Okay. And what about that 2014 communique from the NSW chief psychiatrist? There were criticisms.
Yes, Justice Action raised concerns. They argued it wasn't clear enough in defining serious harm under Section 14 of the Act.
The key trigger for coercive treatment.
Exactly. The worry was that this lack of clarity could lead to interpretations that are too broad, maybe making some CTOs potentially unlawful.
So they wanted it changed.
They called for it to be withdrawn and replaced with clearer, more accurate guidelines.
It's interesting to contrast that with how Victoria defines mental illness in their act.
It is quite different. The Victorian Mental Health Act of 2014 explicitly states things that don't, on their own, mean someone has a mental illness.
Such as?
Things like having an intellectual disability, using drugs or alcohol, your socioeconomic status, cultural background, family conflicts, or even just having had mental health treatment before. None of those automatically equal mental illness under their law.
That seems quite specific.
Yes, and Victoria's mental health principles also really emphasize supporting overall well-being, using the least restrictive options, respecting diversity, promoting recovery and participation, quality and safety, and involving carers. A different framing.
Okay, one last area, international views, specifically on phone and internet access for inpatients.
Right. In the UK, the policy actually encourages psychiatric units, non-forensic ones, to let patients use their own devices access NHS Wi-Fi.
Why?
It's seen as aligning with human rights principles like Article 8 of the European Convention on Human Rights, the right to private life and correspondence.
And Scotland.
Similar idea. Guidelines there say detained patients' calls shouldn't generally be banned, and they should have reasonable phone access. Mobile phone restrictions are only allowed for specific safety or security reasons.
So, wrapping up this deep dive on community treatment orders, well, it's clearly a really complex picture.
Absolutely. We've seen their original aim, community treatment, moving away from institutions. We've looked at the legal processes and the fact that, well, they seem to be used more and more.
And crucially, we've dug into the big criticisms and concerns about people's rights, their freedom.
Yeah, and questions about whether they actually work as well as intended, plus the potential for bias or inconsistency in how they're applied. So you, as someone listening and thinking about mental health support, can see all these threads are tangled together.
It really is a tricky balancing act, isn't it?
Totally. You've got the need to provide care, ensure safety for the person and the community,
Right.
but weighed against fundamental rights, individual autonomy, and the risk of interventions feeling coercive.
So maybe a final thought for you to chew on. Thinking about everything we've discussed, the different viewpoints, the ethical tightropes involved with CTOs, how can we as a society best support people facing mental health challenges while really protecting their fundamental rights and making sure the care is genuinely about them, their needs, their preferences?
Yeah, that's the core question. We definitely encourage you to look deeper into the sources if you're interested and keep thinking critically about this really important area.